What's the price of justice? Our exclusive 7 News investigation found very poor defendants spend more time in jail, and they're more likely to be convicted of crimes for no other reason than they cannot afford their freedom.
Our investigative team spent months analyzing thousands of criminal cases. And tonight in this special 7 News presentation, Locked Up for Low Income, Gordon Dill is joining us now to break it all down. And
Gordon, we're not talking here about criminals who actually get convicted and sentenced to jail, but people who actually spend time behind bars when they're still presumed to be innocent.
Right, so exactly. We're talking about bond. And in this case, we're going to show you by the time we're done that something you've always suspected is true is. Our courts do treat people differently depending on how much money you have. But before we get to that, let's quickly explain exactly what bond is.
The basics will sound familiar to anyone who's seen an episode of Law and Order. When police arrest someone charged with a crime, that person's going to jail. But remember, that defendant is still innocent until they're proven guilty in a trial or they plead guilty. Those trials may take months or longer. For some serious crimes, it takes years. So bond is what happens in between. 4 times a day at the Greenville County Detention Center, defendants are lined up before a magistrate judge. First, under South Carolina law, that judge can allow the defendant to leave jail based on the suspect's promise to show up when their case goes to court. This is called a personal recognizance, or PR bond. But if the judge thinks there's a chance the defendant won't show up or there's an unreasonable danger to the community, there may be extra restrictions. This is an appearance or surety bond. That's what's really happening when you hear someone's out on, say, $10,000 bond. Usually, the defendant can get that money from a bail bondsman who charges anywhere from a 5 to 15% fee. So a $10,000 bond would really cost the accused about $1,000 cash. Once that money's paid, again, the still technically innocent defendant gets out of jail until the trial.
So here's the problem. If you're very poor, even a small cash bond might be too expensive. If you're broke, $500 may as well be $5 million. And if you can't afford to pay up, you're going to stay in jail, even if you're totally innocent of the charges against you. That can mean months away from your family. It can mean losing your job and your freedom, of course. And that's not all. Our investigation can now prove those people stuck in jail sometimes end up admitting their guilt because it's the fastest way to get out of jail.
Ken Bowens got into the wrong car. He was in a passenger seat when police stopped his nephew at this Greenville intersection in April 2014. According to the police report, the officers searched the car and found 1 rock of crack cocaine. Bowens and his nephew were both charged with possession, and both went to jail. The case against Bowens would later be dismissed at a preliminary hearing, but not before an innocent man spent 68 days behind bars. Greenville County Public Defender John Malden says that's because defendants like Bowens aren't in jail for breaking the law. They're locked up for being poor.
Poor people, when they are arrested, will stay in jail because of the inability to post a money bond.
The judge set Bowens' bond at $10,000, which he told us he couldn't afford. His public defender made a court motion for a lower bond, but under court rules in Greenville County, that process takes a minimum of 45 days, sometimes longer, all while poor defendants who are charged but not convicted stay locked up.
If a person can't make the bond that the magistrate set, they are going to be in jail for a couple of months almost every time.
So some pay with their freedom, while you pay millions, because every person in the Greenville County Jail, including those still waiting for trial, costs taxpayers at least $40 a day. Solicitor Walt Wilkins told us his office has as many as 90 bond reduction requests every month. And we found several cases like Bowens where someone spent at least a month behind bars for a crime they did not commit.
Clearly, the ability to pay bond impacts what happens before a case goes to trial, but now we've learned something new. It also affects the outcome of the case. Poor defendants who are stuck in jail are way more likely to plead guilty. In fact, for some of them, pleading guilty is the fastest way to get out of jail.
Which of these columns shows the average bond?
Our investigation compiled more than 3,000 cases by combining records from the Greenville County Detention Center with court files for every person facing one of 5 felony charges over a 3-year period. These defendants were accused of crack or meth possession, marijuana, shoplifting, or larceny. We're only looking at those cases where a judge set a cash bond. And by separating those who were able to pay up and get out within 3 days from those who spent at least a month behind bars, the trend was clear. People who can afford to get out can afford a better outcome.
They're not eating 3 hots in a cot in a jail cell. They're sitting at home on their bond, however, but they're sitting at home going about their daily lives. So they have no incentive to want to come in here anytime soon and sustain that criminal conviction.
Solicitor Wilkins says his office does prioritize cases in which a defendant is stuck in jail, meaning they try to get to them faster. And any defendant can request a speedy trial. But in a criminal case, quick trials often benefit the prosecution. And our investigation found somebody who's out on bond can delay a trial long enough to avoid conviction altogether.
Somebody who is able to post bond quickly does have mechanisms available to them to delay the trial,
Yes.
which does, to some degree, however small,
Yep.
lessen their chances of a conviction down the road.
Potentially. If they post bond, the incentive is to delay the case. They want to delay the case because delay means witness statements change, cops move out of town, things change, the case gets stale.
Just take a look at what happened when we visited the detention center one afternoon in late March. The magistrate judge will set bond in 3 cases. In one, a man is charged with begging. The judge told us before the hearing she'd give him a PR bond. But once the hearing starts, the accused beggar says he's homeless. Without a permanent address, the court can't send notices about his case and can't be sure he'll show up for trial. Without that address, he's headed back to his cell, where the accused beggar could stay in jail for months, charged with a crime where the maximum sentence is just 30 days. This man doesn't speak English, so he's speaking to the judge through an interpreter. She set his bond at $5,000.
So if I don't pay that bond, how many days am I going to be here in jail?
You can sit here anywhere between 3 months to 6 months to 9 months before you go to court.
The longer a person stays in jail, the more likely they are to just say, look, I want to get this over with. I've got to go back home to my family.
Ken Bowens had stayed out of trouble for more than 2 decades until that night in his nephew's car. He told us he couldn't pay the $10,000 bond because his wife was stuck at home in failing health. He got out just in time to tell her goodbye.
So Ken Bowens told me when he was arrested, his wife had about 3 months left to live. Well, she died about a month after he got out of jail, after he had spent about 2/3 of that time behind bars. He got out shortly after his bond was finally reduced. The key takeaway here, guys, is that justice is supposed to be blind. Blind to race, blind to your gender, blind to how much money you have. And it appears that at least in the case of bond, that's just not true.
So much to chew on here, Gordon. Some people are going to watch the story, though. They're going to say, look, if you don't want to be in jail, don't break the law.
They are saying that. In fact, if you go to our Facebook page, I saw a lot of comments to that effect already where people are saying exactly that. So let's be fair to solicitors here. They don't prosecute somebody with a crime unless they believe they have enough evidence to prove the defendant is guilty. But remember this, someone charged with a crime in America is innocent until proven guilty.
So with the bond situation, if bond is unfair, what can we do about it?
Here's the hard question. I knew that question was coming, and I'm still struggling to answer it well. And we've been talking about that in our newsroom for months now. How do we answer this question of what to do next? The best answer we've gotten from talking to prosecutors, judges, and defense attorneys is that public defender. And you saw John Malden in our story. You have to qualify to get a public defender. You can't just say, I'm too poor to hire a lawyer. So it's possible the process could be streamlined where once somebody's qualified as too poor to hire a lawyer, that information could become factored in with the bond. That's one idea, and I want to be careful here. Another thing people will say, and we've done this story 100 times, and I know you guys know this. When we do that story, somebody is arrested, charged with a crime, they get out with bond, and they almost immediately go out and commit another crime, and that's the real problem judges have here. You don't want to let the wrong person out on bond. But guys, money is not the determining factor in that. It's public safety, or at least it should be.
Well, you've given us a very clear and insightful look at what's going on inside our courts in that early process in criminal cases.
It's complicated, but it's very important stuff.
Yeah.
Thank you, Gordon.